these days and how that's going to encourage brownfield development. We heard from Norman Rankin on a number of top tips coming out of the Ministry of the Environment. We also started to delve into this whole notion of what is OREG 15304, how does it work, how do we begin to get to a cleanup, what are the standards, and all those other good sort of practical things. Now I'd like to introduce Donna Shier. Donna Shier is my partner at Wilms & Shier Environmental Lawyers. Donna is going to explore the world of risk assessment for us. And risk assessment is, I think in a nutshell, about customizing cleanups where for whatever reason the standards of the day, the new standards of the day are not applicable to that particular site. Donna Shier is certified as a specialist in environmental law by the Law Society. She's been practicing in the field of environmental law and land use planning since her call to the bar in 1978. Donna is environmental counsel to several of Canada's leading industrial companies, and she's also frequently retained by real estate lawyers and corporate commercial lawyers to act on the environmental aspects of their clients' transactions and site cleanups. So Donna, over to you.
I see this person over here doing the math. I'm 53. Good morning, everyone. Thank you, Marc and Alex, for inviting me, and thank you, Norm, for setting the benchmark for fast talking. I'm going to keep the pace up because I've got a lot to say. My topic is risk assessment, and this term has a special meaning under the Brownfields Amendments. It's defined in the EPA with processes, procedures, and contents prescribed by the new Regulation 153. Risk assessment now replaces the former site-specific risk assessment under the old cleanup guideline. In exchange for what can be a humongous savings in the cost of cleanup, or in situations where cleanup is impossible, contaminated property can be developed on the basis of risk assessment. Owner's team of experts under the supervision of a qualified person conducts the studies that assess risks to human health and to ecology of leaving specified contaminants on a property. When a risk assessment is accepted by an MOE director, a qualified person can certify a record of site condition. And all of those are fancy words. Record of site condition, certify, qualified person, risk assessment, and the subjects that have to be assessed. Here are some situations where an environmental lawyer and consultant team might recommend a risk assessment. Where no background or generic standard exists for the contaminant of concern. Where removing contamination will require demolishing an existing building that is still useful. Where meeting generic standards would require removal and disposal of vast amounts of only moderately contaminated soil. Where contamination levels cannot be reduced to meet the generic criteria at reasonable cost. Where contamination continues to move on-site from neighboring properties, or where the property is situated in an environmentally sensitive area as prescribed by regulation, and an assessment of risk is necessary to verify that the application of generic standards is suitable. Risk assessments provide an alternative to situations where generic cleanup is impossible, impractical, or not affordable. However, risk assessments are not inexpensive, they're not simple, and they're not quick. They involve teams of experts from various technical and scientific disciplines who must meet the requirements prescribed by regulation. The process includes pre-submission approval by the MOE, a range of studies to assess human health risks and ecological risks, and final approval by an MOE director. The risk assessor must consider all the issues specified in Table 1 to Schedule C of the new Reg 153, and those are appendices C and D to my paper. Now, when you look at it, the numbering in the table is incorrect, and that's a computer glitch. For some reason, when we printed it, the numbering goes from 4 to 11. It really is 1 to 8. Don't ask me. For example, a human health risk assessment. No, for a human health risk assessment for each contaminant of concern, The risk assessor must characterize receptors, analyze pathways, estimate exposures, assess toxicity, and characterize health risks. For both the human health and ecological risk assessment components, risk assessor must ensure that the risk assessment report discusses uncertainty. That is, the manner and extent to which uncertainty of measurement or uncertainty of scientific knowledge affect the interpretation of risk in the report and the need to manage risk. The risk assessment report is referenced in the record of site condition with a certification by the QP that the director has accepted the risk assessment under the specified section of the EPA. There is nothing in the brownfields amendments that requires disclosure of the risk assessment report to a third party. A neighbor, prospective purchaser, or other third party seeking to review the report would presumably have to make a Freedom of Information request or seek it from the owner. Once a risk assessment has been accepted, the MOE director will likely issue a certificate of property use that imposes terms, conditions, and restrictions on the use of the property by the owner, by occupants, and by future owners and occupants. Registration on title of a notice of this certificate may be one of the results of the risk assessment process. In my paper, I've set out the definitions of the relevant terms, risk assessment, QP, certificate of property use, and so on. You'll find that there. Let me go back for a minute. When we got the guideline for use in 96, 97, I remember predicting that site-specific risk assessments would only be undertaken in the most extraordinary of situations. We all thought they would be too costly, too time-consuming, that the procedures were too onerous, and that the outcomes were too uncertain. Notwithstanding all of that uncertainty and imprecision, properties were developed on the basis of site-specific risk assessment. My view is if developers undertook site-specific risk assessment before, how much more so now? The codification of the risk assessment process has added elements of predictability that were missing under the guideline. Look at the elements of certainty we now have. Risk assessments are defined in the Act, and the requirements are prescribed by regulation. We know that risk assessments must be supervised or performed by QPs with at least a certain level, 2 years of experience. We can assume that the mandatory pre-submission consultation will improve outcome predictability by getting all parties roughly on the same page before all of the work is done, though consultants are complaining that they have to do an awful lot to get through the pre-submission. I do note, however, that there is no prescribed time limit within which the director must review and comment, accept or reject the pre-submission. Other speakers have commented on that earlier. The director now does have a prescribed time limit to accept or reject the risk assessment, though. And depending on the kind of risk assessment, the time limit is prescribed in the reg. This should improve turnaround. However, this is a soft deadline. There is no procedural remedy for an owner to rectify the failure of the director to respond within the deadline prescribed. Proponents will not have to engage in third-party peer review, though the MOE does plan to charge fees for risk assessments and will use private consultants to review the pre-submission and the final submission. So it'll be an MOE peer review. We now have a standardized risk assessment report format mandated by regulation, and we can only assume that this standardized format is designed to speed up MOE review. Qualified persons have more flexibility and discretion. They can decide which contaminants of concern to include, to assess under new science, or to leave out. The confusing distinction between level 1 and level 2 management categories is eliminated. Certificates of property use may be issued by the MOE for any risk assessment. I think these factors make for added certainty, not just for owners, but also for the consultants who prepare the documents. In sum, I think that risk assessments will proceed with more predictability now under the new law. I also want to say that, notwithstanding how keen I am on risk assessments will be even more demanding and more costly than under the guideline. But they do provide an attractive way to develop properties that would otherwise remain albatrosses. Okay, now I want to move to a pre-submission and MOE acceptance of risk assessments. In the paper, it's called pre-consultation and MOE, in the program table of contents, it's called pre-consultation and MOE approval. But that's not correct, and this is very technical stuff, so we should use the proper terminology. The proper terminology is PSF, pre-submission form, and MOE, acceptance of a risk assessment. The legislation provides that a director can accept the risk assessment, not approve it, accept it. And the legislation requires completion of the PSF. Now, pre-submission. I've included the 21-page risk assessment pre-submission form as Appendix G. The EPA says that where an owner submits a risk assessment, the director will, within the timeframes prescribed by the regulation, accept it or reject it. The regulation does give us the timeframes I mentioned earlier for risk assessment acceptance. But we also know that a risk assessment cannot be completed until the pre-submission form is accepted. While Reg 53 does not use the term accepted for pre-submission, Schedule C, Section 3 does require, it says, preparation of the pre-submission form. The pre-submission form must contain certain specified information and must be in a certain prescribed format. And the pre-submission must include any other information required by the director, and that's what the reg says. Curiously enough, the section says, the director shall review the pre-submission form and may provide comments with respect to the owner, with respect to it, to the owner of the property. So it seems to me that your risk assessment is a non-starter unless your pre-submission is accepted. But what can you do if the MOE doesn't accept your pre-submission or doesn't even respond to it? There's no remedy in the statute. It's going to be interesting to see whether we can successfully challenge the director's refusal to accept a pre-submission or to comment on it. Now I want to go to the risk assessment submission itself, and more particularly to its acceptance. There are all sorts of mandatory requirements for the submission of a risk assessment, as to format and as to contents both. What we know is that the director is supposed to, within the time frame prescribed, accept the risk assessment or give both notice and reasons for refusing to accept the risk assessment. The EPA says the director's decision to accept or reject can be out of time. It doesn't exactly say that. It says that the director's decision to accept or reject is not invalid solely on the basis that the decision is out of time. My view is that that section will be argued as an entitlement for the director to be late. And that's an aside. The point that I really want to make here is the director's obligations to specify reasons in the notice refusing to accept the risk assessment. When I see the requirement to give reasons accompanying a decision, I always think about judicial review. And I'm interested to see if the court finds the director's non-acceptance of a risk assessment eligible for review under the JRPA. I think it's pretty clear there that there is no right of appeal from the director's non-acceptance of a risk assessment. And I can contrast that with all the rights of appeal that there are. If you want to look at that, you can look at Section 13, Part 13 of the EPA. The good thing for property owners doing risk assessments is that I don't see how a third-party neighbor can challenge the director's acceptance of the risk assessment. There's nothing in the EPA, and the director's acceptance of a risk assessment is not prescribed as an EBR instrument, giving rise to that route of appeal. Municipalities, on the other hand, do get a chance to get their oar in. Where the risk assessment assumes that the groundwater criteria against which the risk is assessed is that of a non-potable water supply. So it's in that specific situation. Then, property owner is obliged to give notice to the municipality, and the municipality has the opportunity to indicate that it objects to the non-potable assumption as a basis for the risk assessment. If the municipality does object, we have yet another timing glitch. Note that here, too, the municipality is obligated to give reasons for the objections, and again, I suppose we're obliged to consider judicial review. I can't but imagine that a municipality's refusal to accept a non-potable risk-based assessment will mean that your assessment is a non-starter with the ministry, but we'll see. Finally, certificates of property use. I want to leave the uncertainties of getting your risk assessment accepted for now and turn to these forms of certificates. As I noted in the paper, in the old days, that is pre-October 1, when the director approved an SSRA, the director could ensure that the owner observed the engineering or technical requirements of the SSRA by imposing a preventative measures order under Section 18 of the EPA. Now the director's jurisdiction is the EPA Section 168.6. It says that when the director accepts a risk assessment, the director may issue a certificate of property use. The certificate of property use can set out terms, conditions, and restrictions that bind owners and future owners and that bind occupants. The purpose of these terms and the conditions is to ensure that the risks to the environment and humans from the contaminants left on site do not exceed the level of risk that the MOE accepted when it accepted the risk assessment. So certificates of property use can contain far-reaching conditions and restrictions, and notice of the certificate can be registered on title. So remember, this is a practice tip for deal doers here. Remember three important things about certificates of property use. A CPU is an administrative instrument. It must be complied with unless it is appealed to the review tribunal and varied. Appeal provisions are found in the EPA, and they're numerous, and the deadlines for appealing are tight. Unlike some other MOE instruments, CPUs are not prescribed on the EBR, so no notice is required to be posted, and there's no EBR right for a third-party appeal. CPUs can contain the requirements for financial assurance to guarantee performance of owner's obligations. The MOE director who issues the CPU can require the owner and future owners to give a copy of the CPU to every person who acquires an interest in the property. Practice tip. A transaction is voidable by a person who acquires an interest without first receiving a copy of the CPU. The Act sets out one more important limitation on the power of the director when issuing a CPU. The director cannot use a certificate of property use to require a reduction in the concentration of any contaminant to below the level specified in the risk assessment. That's an important limitation because to do that would defeat the whole risk assessment. My paper discusses additional certificate of property use provisions that will take effect once the mandatory land use provisions of the EPA are passed. These will provide notice to municipal officials and restrictions on building permit issuance. Finally, transition issues. Risk assessments are complicated and they require a technical team expert in many disciplines. The transition from SSRA to the new regulated RA imposes new requirements. My paper identifies the relevant provisions of the legislation and the MOE technical updates describing MOE policies for transition from SSRA to RA. Let me just tell you that based on our firm's experience to date dealing with the transitional provisions, it's fair to say that, I don't know how you put this in print. It's fair to say that they're difficult to work with. Practice tip. anyone trying to take advantage of the traditional rules should absolutely take a thorough look at the basic technical work that has been done and at their consultants' Ontario qualifications before even thinking about going forward. That's critical. We already have some stories that are in midstream, but I'm not so optimistic about how they'll be resolved. Anyway, that's it for now. Did I go over time?
You're good.
Thanks.
Thank you very much, Donna. Well, next we turn to two topics that are of interest relating to the recovery of costs. And we're going to turn to Michael Kovacevic for that in a moment. And then we're going to have a panel discussion about the scope of liability under the brownfields legislative regime. I think in terms of incentives, Michael, one of the questions that I certainly have is this the icing on the cake? In other words, are there real incentives? And Michael Kovacevic is going to help us out with that, I do believe. Michael is an associate at Goodman and Carr. Michael practices in the areas of municipal law, land use planning and development law, and property tax law. Michael appears before tribunals and courts, including the Ontario Municipal Board. He represents his tax clients on property tax assessment appeals, municipal property tax assessment disputes, and property tax due diligence on property transactions. So Michael, over to you, please.
Thank you, Marc. Good morning, everybody. I'll jump straight in. When you're looking at the granting of tax relief in Ontario, you have to start with two basic principles. The first is contained in Section 3 of the Assessment Act, and it provides that all real property in Ontario is liable to assessment and taxation, subject to the exemptions contained within that section in the Act. None of those exemptions apply to what is commonly known as a brownfield property or the redevelopment of a brownfield property. The second principle is contained in Section 106, sub 1 and 2 of the Municipal Act. They're commonly known as the bonusing provisions of the Municipal Act, and they prohibit a municipality from assisting directly or indirectly any commercial enterprise through the granting of bonuses. Now, assistance is defined in that section to include the giving or lending of money or the granting of total or partial tax relief. In the context of brownfields, three exceptions exist to these two general principles against providing tax relief. The bonusing provisions in the Municipal Act in Section 106, sub 3, provide that the prohibition does not apply to municipalities exercising their power under Section 28, sub 6 or sub 7 of the Planning Act. These are commonly known as the community improvement provisions of the Planning Act. In addition, the Brownfield Statute Law Amendment Act amends Section 106 such that the bonusing prohibition found there does not apply to a municipality exercising its power underneath the new Section 365.1 of the Municipal Act. Finally, the prohibition also does not apply in the case of agreements entered into pursuant to Section 110, sub 3 of the Municipal Act respecting municipal capital facilities. I'll deal first with Section 28 of the Planning Act. As I stated, it contains the community improvement plan provisions of that act. These provisions are a tool for effecting improvement in areas which, in the opinion of a municipal council, are in need of improvement because of their age, dilapidation, overcrowding, faulty arrangement, unsuitability of buildings, or other environmental, social, or community economic development reasons. Brownfield properties fall within the scope of what's deemed to be an improvement. To exercise its powers under Section 28, a municipality has to have community improvement provisions inside its official plan. And it must designate an area as a community improvement project area, and it must adopt a community improvement project plan for the community improvement project area. Under Section 28, a municipality can make loans or grants for the purposes of carrying out the community improvement project plan to pay for the whole or any part of the cost of rehabilitating lands. The grants or loans cannot exceed the cost of rehabilitating the lands or buildings. While this power is not a direct tax reducing power or tax cancellation power, there's no prohibition in the Act which would prevent a municipality from having the amount of the loan or grant determined by reference to the level of taxation of a property before or after it's redeveloped. And in fact, municipalities with community improvement project plans for brownfields that offer such grants most often calculate them by reference to the level of taxation of the property. In order to exercise its power under Section 28, a municipality must first obtain the approval of the Minister of Municipal Affairs and Housing. This approval has been delegated to the municipal services offices of the ministry. Now, Section 365.1. This section in the Municipal Act expressly grants a tax cancellation power. A municipality can pass a bylaw canceling all or a percentage of taxes levied on eligible properties for municipal and school purposes during what's called the rehabilitation period. If such a bylaw is passed, the municipality can then also pass a bylaw canceling all or a percentage of the taxes for what's called the development period. So to understand the grant of power in this section, you have to understand what rehabilitation period means, what development period means, and also what an eligible property is. And they're all defined right in Section 365.1. An eligible property is one for which a Phase 2 environmental assessment has been conducted. It must be in a community improvement project area for which a community improvement project plan is in effect, and the community improvement project plan must contain provisions for tax assistance under Section 365.1. As of the date of the completion of the Phase 2 environmental assessment, the property must not have met the standards under subsection 4.1 of Section 168.4 sub 1 of the Environmental Protection Act to permit a record of site condition to be filed in the Environmental Site Registry. Now, the rehabilitation period for a property is defined as the time period starting on the date the tax assistance begins and ending on the earliest of 18 months later, or the date the record of site condition for the property is filed with the Environment Site Registry, or the date this tax assistance equals the sum of the cost of any action taken to reduce the contaminants on the property in order to permit a record of site condition to be filed in the Environmental Site Registry, and the cost of complying with any certificate of property issued under Section 168.6 of the Environmental Protection Act. The development period means the period of time starting on the date the rehabilitation period ends and ending on the earlier of the date set out in the bylaw granting the tax relief, or the date the tax assistance once again equals the sum of any action taken to reduce the contaminants on the property in order to permit a record of site condition to be filed in the Environmental Site Registry, and the cost of complying with any certificate of property issued under Section 168.6 of the Environmental Protection Act. Now, prior to passing a tax assistance bylaw under Section 365.1, a lower tier municipality must give notice to its upper tier municipality of its intention to pass the bylaw, and the upper tier will then decide if the bylaw will also apply to a cancellation of all or a percentage of the applicable upper tier taxes. Similarly, a municipality, whether it be a lower tier or local municipality, has to give notice of its intention to pass the bylaw to the Minister of Finance. If the bylaw is approved in writing by the minister before it is passed, it will also apply for a reduction of taxes for school purposes. If it's not approved by the minister, it will not apply to taxes for school purposes. If the bylaw doesn't apply to either the applicable upper tier municipality or school boards, the amount of taxes paid to them will not be affected. Only the lower tier municipality or local municipality will suffer a tax revenue loss. In order to receive tax assistance under Section 365.1 for underneath a bylaw passed under it, the owner of an eligible property has to apply for that tax assistance. It's not automatic. Now, there are differences between the program under Section 28 and under Section 365.1. And there are advantages in respect of the different programs. Section 28 offers more flexibility in terms of the amount of financial assistance and the eligibility of a property. Why? Well, because Section 28 does not contain the rules for the provision of tax assistance that are set out in Section 365.1. There's no timing restrictions like there are in Section 365.1. Under Section 28, a municipality can wait until the redevelopment is completed to provide a grant or loan. This ensures that the development is actually carried out before a municipality provides assistance. Also, By waiting until the redevelopment is completed, a reassessment can occur, which will allow a municipality to calculate the incremental tax increase resulting from the redevelopment, rather than relying on pre-development estimates. The incremental increase can then be used as a benchmark to calculate the appropriate grant or loan. The less restrictive timing provisions in Section 28 may also allow a municipality to provide greater financial assistance than that provided under Section 365.1. That's because the timing restrictions under Section 365.1 may result in tax assistance being provided during periods when the eligible property is vacant or undergoing development. Tax rates for vacant lands are lower than for developed lands. Further, brownfields are often located in areas with depressed land values and therefore, in theory, depressed assessed values, which results in theory in lower taxes. In addition, the Municipal Property Assessment Corporation, or MPAC, traditionally avoids taking into account the effects of contamination on its assessment of land values. However, if the assessment is appealed and it can be shown that the value of the land is affected by the contamination, which in some cases reduces the value of the land to a negligible amount, MPAC will often settle for a significant reduction in assessed value so as to avoid setting a precedent before the Assessment Review Board. The result of lower tax rates, lower general land values, and successful property tax appeals often leads to negligible taxes being paid in respect of brownfield properties, and hence the tax provided for under Section 365.1 may be meaningless, especially during the rehabilitation period. Now, the flexibility in Section 28 comes at a cost. Under Section 365.1, the tax relief can be funded from three sources: lower tier taxes, upper tier taxes, and school taxes. Under Section 28, the tax relief comes from the level of municipal government implementing the Community Improvement Project Plan and not from other sources. Now, the final area of tax relief is Section 110 of the Municipal Act. This is known as the Municipal Capital Facilities part of the Municipal Act. Under Section 110, a municipality can enter into an agreement with a private party for the provision of municipal capital facilities. Municipal capital facilities are defined in Ontario Regulation 46/94. And basically what's set out in the regulation is a list of what constitutes a municipal capital facility. I won't go through them here, but it's a fairly lengthy list. Most of the listed elements in the definition are infrastructure. But municipal and social housing is also another type of municipal capital facility. Other facilities include tourist facilities. Such facilities may be relevant in terms of what a developer may actually want to develop on a property. Now, Section 110 sub 3 allows the municipality to provide financial or other assistance at less than fair market value or at no cost to the person entering into the municipal capital facility agreement with the municipality. It includes the giving or lending of money and the charging of interest and the exemption from municipal and school taxes. Therefore, for those portion of a brownfield development on which municipal capital facilities will be located, tax relief can be provided and the timing could be geared to the cleanup period. Also, if a developer wants to redevelop a brownfield site in a public-private partnership with a municipality, for example, for social housing or for, say, an arena, there may be an option for the reduction of taxes. I'm going to talk about some examples of tax assistance programs that are currently being implemented in Ontario. I'm going to go through three examples, programs that are in place in Hamilton, Kitchener, and Kingston. Now, these aren't the only municipalities with programs. There are programs in a number of other municipalities. Hamilton's program is called the Environmental Remediation and Site Enhancement, or ERASE, Community Improvement Plan. It's implemented pursuant to Section 28 of the Planning Act, and it contains a comprehensive set of programs created to encourage and promote brownfield redevelopment in the older industrial area of the city, which is an area encompassing approximately 3,400 acres. It provides grants that are available to property owners who undertake and complete redevelopment projects. Grants cover the cost of environmental remediation and environmental studies, demolition and site preparation, including the construction and improvement of on-site public works. The grant is payable when the redevelopment results in an increase in assessed value and property taxes. The total amount of the grant is calculated as 80% of the increase in the municipal portion of the property taxes resulting from redevelopment. There's no upper tier municipality in Hamilton, so only the school taxes are missing from the tax break. The grant application must be made to the city, and only costs incurred after the application is approved can be included in the grant payment. Kitchener's program is provides similar assistance to Hamilton's. It's called the Brownfield Remediation Community Improvement Plan. The goal of the program is to increase the level of development of attractiveness of brownfield lands in the city to a level equal to similar greenfield lands. It's also implemented pursuant to Section 28 of the Planning Act. It offers tax incremental financing, or what's commonly known as a TIF. A TIF in Kitchener is defined to mean the difference between the current tax level of a property and the future tax level after cleanup and redevelopment. A portion of the tax increase or increment is used by the city as a future incentive to aid in the funding of the cleanup of a property. In exchange for a completed and filed record of site condition or approved site-specific risk assessment, Kitchener will provide a grant. It's paid annually for a period of up to 10 years as a rebate on city taxes in an amount equal to 100% of the city tax increment, which is the difference between the city portion of the property taxes as of the date of the application and the new city portion levied as a result of the new assessment made by MPAC following the project completion. Kitchener is a lower tier municipality in the region of Waterloo. Therefore, only the lower tier taxes will be reduced in its program. The grant is paid after redevelopment in the first year following reassessment. It will continue for 10 years or until the total eligible remediation cost has been reached, whichever comes first. The eligible remediation costs are the costs of conducting the Phase 1 and Phase 2 environmental study and remediation costs of Phase 3 and 4 and associated consultant fees. The program has eligibility requirements, one of which is the property has to be historically contaminated, or in other words, the contamination had to have resulted from previous owners of a non-residential use. A property is not eligible if it became contaminated after the date Kitchener approved its program. Last municipality I'm going to talk about is Kingston. It contains a similar program to Hamilton and Kitchener's. That's not surprising since it also was created pursuant to Section 28 of the Planning Act. It's entitled the Kingston Erase Community Improvement Plan. It provides financial relief in the form of grants to property owners who undertake remediation and redevelopment of a property that results in increased assessment and increased taxes. It's also a pay-as-you-go program. In other words, financial relief is only provided after the redevelopment is complete, and the owner must pay the property taxes each year. The city will then provide an annual grant based on the incremental increase in property taxes resulting from the redevelopment. The grant is paid for 10 years or until eligible program costs are paid. Eligible costs are defined by the city as all works necessary to remediate the subject property. The grant equals 80% of the incremental property tax increase. The remaining 20% is dedicated to another program entitled Erase Municipal Property Acquisition, Investment, and Partnership Program. A calculation of the incremental increase is essentially the same as in the Kitchener program. What's different in Kingston is the screening process for applicants. They're screened by an evaluation committee which evaluates and recommends an application for approval based on the program requirements specified in the Community Improvement Plan and any other requirements set by the city. The owner or the developer has to enter into a redevelopment agreement which specifies the amount of the grant, its duration, the owner's obligations should he or she default, and any other requirements of the city. The evaluation committee negotiates the agreement with the owner or developer. The city may request a business plan to be submitted by the owner or developer, which is required to contain information such as the duration of the remediation, conceptual drawings of the redevelopment, an assessment of taxes, an estimate of the taxes post-development and an estimate of the assessment post-development, details of remediation works to be completed, and an estimated costs of remediation. The city will use this plan to assess the application's viability and the viability and long-term effectiveness of its program. The applicant has to submit a Phase 2 environmental site assessment that includes a detailed work plan and budget to complete the remediation. Eligible costs to be recovered include environmental studies, environmental remediation, site preparation, including the construction and improvement of on-site public works, and demolition. To be eligible, a property cannot be in a position of tax arrears. I'll just wrap up with some brief conclusions. The programs I've described are relatively new. An evaluation of their success at this time is premature. For instance, I talked to representatives in Cambridge, and they're just starting with their Section 28 program, and they've got another program in place which they've had much more success, which they've had a lot of success with. Now, the new powers under Section 365.1 have not yet been used by municipalities because the section was just proclaimed in force on October 1st. But based on the use of their Section 28 powers, I predict municipalities will be eager to use them to promote redevelopment of their brownfield sites. In fact, Kingston staff have informed me that their community improvement plan will be amended to include powers under Section 365.1 of the Municipal Act, and they're going to submit it to their council in the province for approval. Thank you.
I must say, sitting up here, that life seems just oh so simple, and yet we haven't yet talked about liability. What I'm proposing is that Alex and I are going to shift to the ends of this table. We'll bring our panelists up, and then I'll introduce our next group of speakers.
So you want us to stay up here?
I would like to ask you not to.
Okay, fine. But this is the panel, it's the panel, not the panel.
That's correct.
I'm moving, going.
Thanks, Donna. Yes. Do we need that? Can we not just use these microphones? Yeah. Thank you. Long time no see. I'm missing you. Terrific. Well, I think it's fair to say that there's been much talk and even some criticism about the extent of the scope of liability protection that's being offered under the brownfields regime. I think as lawyers, most of us here are lawyers, our fundamental concern is about how we advise our clients about liability, and of course from time to time this determines our own liability. Some have argued that the provincial government has not gone far enough to extend liability protection. Others have said that the province has gone too far. We have a terrific panel of speakers. They're going to review the scope and limits of liability protection under the brownfields law for us. The panel is going to be moderated by Adam Chamberlain, and we've met Adam Chamberlain. The panelists include Katherine van Rensberg, who's 3 over on my left, also Bryan Buttigieg, second from the far end of the table, and Laura Nemchin, who is sitting on my immediate left. Katherine van Rensberg is a partner with Gowlings. She's a very experienced commercial litigator, and Katherine has devoted a substantial part of her practice to environmental law. Katherine is a specialist in both environmental law and civil litigation. Bryan is a partner with Miller Thompson. Bryan Buttigieg's practice also is somewhat involved with commercial litigation, and I know because I've experienced the wrath of Bryan on the other side that he also focuses on environmental litigation. Bryan defends prosecutions under the Environmental Protection Act, the Ontario Water Resources Act, and the Occupational Health and Safety Act. And Laura Nemchin, and we've managed to get to know one another oh so well of late, practices environmental law with the Attorney General, Ministry of the Environment, and Laura has done so since her call to the bar in 1994. Laura's practice is on environmental litigation. She is involved in court work and also environmental review tribunal work. Laura has been involved with legislative drafting, and in the fall of 2002, Laura was a visiting researcher at Harvard Law School in the United States. So Adam, on that note, over to you, please.
Marc, Thanks. I'm not going to do a lot of the talking here. I'm just going to be a bit of a traffic cop, I guess, if needed. But what we are looking at is the scope and limits of the new liability protection. We're going to start with Laura, who's going to talk a little bit about the RSC exemptions and some related issues, and a discussion more, from the point of view of the Ministry of Environment. Then we're going to turn to Katherine and to Bryan, who will discuss some of the exceptions to the exemptions, as well as a number of related issues. So I'm going to pass it off quickly to Laura.
Thanks, Mark, and thanks, Adam. Just picking up on a comment that Mark made, that some have argued that the protection that we're going to be talking about went too far, and some have argued that it's not far enough. Of course, I'll say that it struck a perfect and delicate balance of all the interests. The way that I think the panelists have decided to structure this is that I'll lead off with a very little bit of background to try to situate the protection that's offered by, and the relevant section that we'll be talking about is 168.7, and it's set out actually at, I think it's page 3 of the paper that's been provided as a part of this panel. At least part of it's been set out, so you may want to turn to that because that might be helpful to look at as I'm going through it. So yes, I've been charged with the thrilling task of taking you through those that protection and to touch a little bit on what the limitations and scope of the protection is, and then I think that the limitations and scope will be discussed in more detail by my co-panelists. So to begin with the background, as most of you know, in 1990, and a lot of this, the protection in 168.7 can be traced back to the legislative amendments that were made in 1990, which significantly widened the pool of who could be liable under orders issued by the Ministry of Environment. In particular, the people who could be ordered was expanded to past owners, occupiers, and persons in charge of management and control, and that introduced a certain amount of uncertainty in the regulated community about liability. And in terms of forward-looking, it also, the expansion of the pool didn't really provide any mechanism to have people who wanted to resolve their liability issues and do so in good faith, or even investigate their liability. There were no formal mechanisms to address those issues. So in part, the ministry responded in the mid-90s with the Contaminated Sites Guideline in 96 and 98, and it was updated in 98. But the Brownfields Act and this particular provision, 168.7, is meant to address that uncertainty. And what we're talking about today, 168.7, is really part of a larger structure of protections that the Brownfields Act introduced, in particular, in terms of the uncertainty about if I go on the property and do an investigation, will I attract liability under orders? That was, we're not talking about this in this panel, but that's also addressed in the Brownfields Act. And it allows municipalities and secured creditors and certain other actors to go on and do certain things without attracting liability. The piece that we're talking about today, though, is the piece that addresses what happens to current property owners who know they have a contaminated site and they want to do something about it. They want to clean it up, and they also want to address their, in some people's view, perpetual and potential liability to be ordered in the future. And so in order to sort of balance the interests of addressing that uncertainty and to attempt to also preserve the ministry's ability to order people who are either responsible or in a position to control pollution, 168.7 was developed. And so if you look at 168.7, the first part of it, subsection 1, talks about when protection from liability against orders, and there are only certain kinds of orders, is triggered. And the trigger is the filing of the record of site condition, which I believe a previous speaker, I think it was Madeleine, who spoke about records of site condition. And they're governed by 168.4. So once an owner files a record of site condition, the protection is triggered. And the thing that you get protected from is issuance of orders under Section 7, control orders, Section 8, stop orders, Section 12, stop orders where there's a program approval, the big ones, Section 17 and 18, Section 17 remedial, and Section 18 preventative orders. And then the provincial officer's orders, contravention orders under 157, and preventative orders under 157.1. So it's a significant protection that's offered by 168.7 on the filing of an RSC. The next issue is, well, who does this actually apply to? And the governing principle of 168.7 is forward-looking. It protects current owners and future owners of that property for which the RSC has been filed. And it protects persons who are in charge management and control or occupants of that property after the record of site condition has been filed. So that's the primary protection. And I think some of my co-panelists will talk about, well, what about past owners? And what about past owners, occupants, or occupants and persons in charge management control? There is a little protection carved out in subsection 1 of 168.7 for past owners. And essentially the section says, if you're a past owner that complies with the regulation, the new regulation 154.04, then you get the protection too. And in essence, that protection is extended to past owners who made it a condition of the sale of the property that an RSC be prepared, filed, and actually filed. And I know my co-panelists will talk to you a little bit about the issues that raises. But again, past owners who sell property with that condition that an RSC be filed and that the RSC is actually filed, they get the protection as well. So with that sort of broad scope in mind, you get the protection from the major orders, well, all the orders addressing contamination in any event, and it's a forward-looking section. The breadth of that protection is then scoped down a little bit with the subsections of 168.7. And I'll just touch on these because I know my co-panelists want to talk about these in a little bit more detail, but just the highlights are subsection 2, which is not reproduced in your materials, but subsection 2 essentially says, if the RSC contains false or misleading information, then the protection is lost. The rationale is obvious that an inaccurate or false RSC undermines the purpose for giving the protection. Subsection 3 says that you don't get protection for off-site migration. And I know my co-panelists will have something to say about that, so I'll just leave it at that, and perhaps we'll have an exchange later on about that. But again, off-site migration is not protected. You could still be ordered for off-site migration of contaminants. If there is a change in the property use, the protection might be removed unless the change in property use triggers less stringent standards, so for example, a residential to industrial property use, and that an SSRA has not, or a risk assessment has not been prepared for the property. So a change in property use might trigger a loss of the protection unless you're going from you're triggering less stringent standards and you don't have a risk assessment for your property. Lastly, subsections 5 and 6 of 168.7 talk about in what circumstances contravention orders, provincial officers' orders under 157.1 can be issued. And there's two circumstances. The first is if you have contravened your certificate of property use, which was discussed earlier this morning, or if you've contravened a condition of your risk management order, then a contravention order can be issued. So the protection is lost. If, and under subsection 6, if a contamination order, if there's been a contravention rather of certain regulations made under, and it's a bit complex, but regulations made under the EPA which address management of soil on the site, essentially for stratified site regulations. If you've contravened one of those, a contravention order may issue, no protection for that. Lastly, the ministry still can issue orders, any order, 7, 8, 12, 17, 18, 157, 157.1, if someone comes and asks, and if they consent in writing to the order. Because there are some situations, as you may know, that people want orders issued to them. Last scoping of this section is contained in 168.8, and that is the section that governs something called emergency orders. Some people call these reopeners, and in essence what the section says is in an emergency, and an emergency is in essence is defined by danger to human health, including water supplies. In those situations, notwithstanding the fact that an RSC has actually been filed for the property, the director still retains the ability to issue a very narrow order. The order can only be issued to the current site owner, and the order can only require measures to address the emergency, to address the risk to human health, including water supplies. So it's a scoped order. The director has to post on the registry a notice of the issuance of the order, post a compliance notice once the order has been complied. And lastly, if there's any change to the RSC as a result of the emergency order, the RSC has to be refiled and has to be adjusted. So those are the sort of highlights in a nutshell of the section. I think we can sort of get into the issues that the protection and the limitations, I guess, of the protection raise. But from the ministry's standpoint, as I sort of said at the top of my talk, I think that there was a real attempt here to balance and to create a scheme that balances the interests of property owners who want to resolve liability issues, who want to develop brownfields, and environmental protection in essence. So it's an attempt to balance those two things, and my client thinks it's a good balance.
Thanks very much, Laura. I'm going to turn now to Katherine and to talk about some of the exceptions and some other specific issues as well.
Thank you. The major concern and impediment to the redevelopment of contaminated sites has traditionally been thought to be the fear of liability. So when the Ontario government announced that they were going to look at preparing brownfields legislation, environmental lawyers and other stakeholders really waited with bated breath to see what they were going to do about this issue of liability, because that really was a centerpiece from our perspective of what they may be able to offer in the legislation. In the months and years leading up to this legislation, there was a lot of controversy in the environmental bar about what the liability exemption in the legislation should look like. And there was a lot of criticism about essentially what is a proponent-driven record of site condition process, where the buck stops at the qualified person and not at the regulatory authority. And that's in contrast with a lot of regimes in US states and under the US EPA, where there is a provision for regulatory sign-off, where the regulator can issue a no-action letter, and where you have the comfort of knowing that at least the regulator has reviewed the information and agrees that the site meets certain criteria. The system that was proposed and that's now implemented in Ontario is very different. It borrowed from existing record of site condition and guideline processes that were familiar to people and has that advantage. But it was also thought to be, by a lot of commentators, something that was not as advantageous as what exists in other regimes. So the temptation today is actually to launch into that debate again and to point out all of the shortcomings in this liability exemption, but I'm not going to do that. And I'm not going to do that for one basic reason, and that is my bias is in this debate is that I'm very much in favor of this legislation. I think that there are some really significant advantages under the legislation that we didn't have previously. And I think it's important to keep in mind that this isn't just brownfields legislation. This is legislation that applies to the contaminated site regime in Ontario. All contaminated sites, whether they are capable of being redeveloped as brownfields, will be impacted by this regime. I think the advantages are really key, that we now have a process for determining when clean is clean, and we didn't have that process before October 1st. We now have regulatory cleanup criteria, and especially in dealing with people from other jurisdictions, it was very hard for them to understand how we could rely on guidelines to guide our affairs. We now have those criteria set out in regulations. We have regulatory qualifications for consultants. This is something that various stakeholders, including the Canadian Bankers Association, for years and years have been after, is to find some criteria by which we can assess consultants' qualifications, and those are now in the regulations. We have statutory acceptance of risk assessments. That uncertainty about site-specific risk assessments, there's still going to be a lot of uncertainty, but before now, we didn't have any acceptance in the legislation of risk assessments. There was a lot of reliance on the discretion of the Ministry of the Environment in dealing with these. There are now processes in there. Companion to that is there is a provision for regulatory review and approval of risk assessments. That's a significant advantage. There's a secured lender exemption for the first time in our legislation. I know that's not been the topic of discussion today. These provisions came into effect in December of 2002. They follow provisions that were in place under various agreements with the Ministry of the Environment, but it's now there in the legislation. I think these are really significant advantages, and I think they can't be underestimated. Now, that said, the record of site condition exemption, which I see as the centerpiece of this legislation, because that's really what people are looking to achieve. If this is voluntary, in situations where it's voluntary, you're only going to follow that process, presumably, if you think it's going to give you an advantage, and that advantage is going to be an exemption from liability. That protection is not without its limits, and what I'm going to do is describe a few of those limitations, and Bryan's going to describe a few of the other limitations that we think it's really important that we as council make sure that our clients understand that this record of site condition exemption does not provide unlimited exemption from liability. First of all, I think one point worth mentioning, and it's not really an exception to the exemption, but it's really found in section 168.71 itself, and that is it's important to keep in mind that the RSC exemption applies to old or existing contaminants. Contaminants at the time that the record of site condition is filed. If new contamination comes onto the property, or if there's a new source of contamination on that property, that record of site condition does not provide any protection from orders in respect of that new contamination. It makes a lot of sense. It may be that we think it goes without saying, but it's really important to remember that. And we as council need to ensure that we don't see this as an excuse or something in lieu of our own due diligence. The due diligence still has to be done to see whether there are existing sources of contamination or new contamination that's come onto a site since the filing of the record of site condition. Another point worth mentioning is that the record of site condition is tied to a particular use of the property. Remember, keep in mind that the site criteria, the criteria for soil and groundwater contamination are tied to particular uses, whether they're residential uses or industrial uses, more stringent criteria for more sensitive uses. the record of site condition exemption is lost if there's a change in use of the property to a more sensitive use, and it's lost to that party who is using that property for the more sensitive use. So it's really important to keep that in mind. Again, as counsel, that's something that should be fairly easy to ascertain. What is the current use of the property? What is the use that was declared in the record of site condition? And is the protection still there? Another point that was mentioned by Laura is that in an exception to the exemptions, the record of site condition protection is lost if there is breach of a condition of a CPU, a certificate of property use. Keeping in mind, again, what Donna was talking about in the risk assessment process, the risk assessment is often tied to particular measures that are going to have to stay in place at that property for a significant period of time, whether it's the installation of a vapor recovery system, whether it's maintaining certain barriers to prevent the migration of contamination from the property. It may be subject to conditions that there's no basement on the property, that the property is not used for a daycare center or other sensitive use. Those conditions, if they're in a certificate of property use, and may find their way on title. If there's a breach of any of those conditions, the record of site condition exemption is lost. And it's important to remember it's lost for everybody. It's not just lost for the party who breaches the condition, but it's lost for the original owner that filed that record of site condition, and it's lost for all the other people subsequently down on the title who may be trying to shelter under that record of site condition. Maybe a little more difficult for us as council to do due diligence on this issue. I mean, in terms of restrictions on the use of the property, that could be capable of being determined. But how are we going to be able to determine, for example, whether a remediation system has been operated properly from month to month over a significant period of years? This, I would anticipate, is going to become more difficult the longer that the record of site condition is in place with these conditions to try and monitor the compliance of other parties over which our clients may have no control. One final point that I wanted to address is the false or misleading information exception to the exemption. This is fairly significant, as you can imagine, that there's a provision that says if there is false or misleading information in the record of site condition, the exemption is lost. A couple of points on this. First of all, at the present time, it doesn't appear that there is any mechanism for the ministry to expunge a record of site condition from the environmental site registry. So that means if you've got a record of site condition on the registry, your client as a subsequent owner may want to get some protection from that. And if there's been a determination made that there was false or misleading information, you may have no way of knowing that except through your own due diligence. Another point, there really aren't any criteria for determining what is false or misleading. Clearly, it's not restricted to fraud. It's not restricted to something that's deliberate. It would make sense that any owner who is filing or making statements in a record of site condition should be required to make honest statements as far as they reasonably can. But the problem is, in the record of site condition, there's lots of other information apart from what the owner provides. There's information that the qualified person provides. And that's where the real nub of it is. The qualified person isn't only providing factual information, but really the real nub of the record of site condition is that qualified person's expression of an opinion that the site meets certain criteria. And that opinion, of course, can be based on, has to be based on their own expertise and their evaluation of the information that they've provided. So it remains a question as to in what situations it may be alleged that information was false or was misleading. And I think there's some risk to our clients as owners in filing these records of site condition that they may be exposing themselves to some degree of liability. Now, Sarah had mentioned in her presentation that she thought I was going to address this issue of owners taking on some additional potential liability. I'm going to do that very briefly before passing over to Bryan. I think this is where the source of concern may be. you'll notice that there is a provision in the Environmental Site Registry. There's a notice that says the Ministry of the Environment, there's a disclaimer, it's called a disclaimer. The Ministry of the Environment is not responsible for the information that's provided on the registry. So they're protected from liability if there is incorrect information. You'll also notice that when the qualified person is required to state certain information in the record of site condition, the qualified person also has a statement, it's a mandatory statement, that they're not offering any warranty. And that was in there because the qualified person said, the insurers of the qualified person said, we won't provide insurance unless there's some degree of protection. There is no such protection for owners. And if you think about it, if the owner is required to certify its own information, but then there is a loss of an exemption in the event that there is false or misleading information elsewhere in any part of the record of site condition, there may be some basis for arguing that that owner could be responsible if there was any information upon which a party relies going forward into the future, because in essence, the owner has got that process going, has voluntarily sought an exemption, the benefit of an exemption, and has allowed that information to go forward. In addition, there is a statement that the owner must make in the record of site condition that says that the owner is aware that the information that's being provided will be provided publicly and available for people's reviews. So I think there's some concern there that there may be some potential liability that may be incurred, and it's fairly difficult to predict where that might end up.
Thanks, Catherine. Bryan?
Thanks, Adam. And just to continue with Catherine's last point, the owner is probably also unable to buy insurance to cover the statements that the owner makes. You have to think about who would actually sign this on behalf of the owner, whether the individual as an employee of a corporation or the owner as if it is a corporation, whether there is available insurance. So this could become a potential problem with some owners being reluctant to take advantage of the protections that are available in a record of site condition. I want to cover a couple of other issues with respect to the exemptions from the exemptions. To some extent, I do fall on the side that Laura mentioned, that people think, well, the protections don't go far enough. But I also want to agree with Catherine that to the extent that there is some protection here, this is a good thing. And in terms of advising clients, I would ask clients to think long and hard about, well, what's the downside of doing this? You're getting some protection, you're getting something better than what you have without taking advantage of this. And, it's something which is well worth considering. One of the things, and again, this falls in, I guess, within the practice tips issue as well, is to be very aware of the fact that there is no protection for prior owners. It's only the owner who registers the record of site condition. It's the limited case of a vendor who is selling the property and as a condition requires the new owner, requires the purchaser to register. That's the only prior owner who will get protection. So there is no protection for previous owners. Two classes of people that this would apply to. One is the historical owners, people who sold the property 20, 30 years ago. There is no mechanism by which those people can now come on side into the new regime and obtain some form of limited protection, even if they want to. As a question of policy, I'm a little bit puzzled by what exactly that is supposed to protect against. There may well be out there owners who 20, 30 years ago did their due diligence, complied with the standards of the day as they were. Those standards, sure, may not be as stringent as they are today, but at the time, as a question of common law, they fulfilled the standard of care of the day. What would be the harm in having a mechanism that allows such a past owner to come on side if a record of site condition is being registered and file a declaration that say, I complied with the standards of the day at the time and here's what I did, and get some protection from that. I'm not sure what mischief is being protected if we don't allow a mechanism like that. Similarly, as a practice tip, if you're advising an owner to sell, there will be higher transaction costs. There will be concerns about, well, do I want to sign as an owner? But they need to balance that with the fact that at the time of sale, this is their last chance to get this protection under this present regime. So they have to keep in mind that orders may become more stringent. Standards may change. This protection, as it is right now, as I read it, will apply even if the standards become more stringent later on. Without this protection, if you're advising an owner, don't worry about the record of site condition. Dispose of the property without going through the transaction costs, without waiting for the time necessary to do it. Well, the ability to come under this protection may be lost forever, at least as presently drafted. Similarly, with respect to the off-site migration issue, this could potentially be a very major impediment. I'm not sure, as an empirical basis, if there's any statistics out there as to how many cleanups or how many sites exist that qualify as brownfields that have zero off-site impact, and how many apply that have some off-site impact. I have a hunch that a large number of them will have some off-site impact. As I am reading the exemption right now, the protection from orders really only applies with some certainty to those sites for which there is zero off-site impact. If you look at the provision, the wording of section 168.6 sub 2 says that the ministry may still issue orders if, after the certification date, any of the contaminant moved from the property to which the record of site condition relates to another property. So what you need is some migration of some portion of the contaminants. Well, what does this mean in practice? There may well be cases where there is some off-site contamination at the time of a remediation that is very small. There may well be cases where it's not practicable to deal with it, where it's not desirable to deal with it. A classic case that many of you may have seen is a question of contamination under a road allowance. Municipalities don't like you to dig up their roads when it's convenient for you doing your cleanup. Very often what we would do with the municipality is arrange with them that here's what's being left behind on the road allowance. When you, the municipality, are next in there doing some digging of your own, if you incur any incremental costs, the owner of the property will pick that up. And that's usually advantageous to both people. Similarly, if there is off-site contamination that's within guidelines that doesn't affect the use in any way of the property, the reality is, however, that as long as there's groundwater, there's going to be a mechanism for transport. And as long as that's the case, any molecule crossing a property boundary is, as I read the section, going to bring you within the section that says the MOE may still issue orders. And the ability, as it's drafted right now, isn't just to issue orders to deal with the off-site contamination. It's to deal with the entire contamination, such as it may be. Now, as a practical matter, it may be that you can say, well, the source has been taken away, the property has been remediated, there's not much going to be moving off-site. But again, if we're advising clients that you're going through all this to get the protection, what can we tell them when we tell them that, in addition, if somebody makes a determination that one molecule has crossed a property boundary, you've lost that protection? I would hope that the ministry, as a matter of policy, would adopt what I suspect they will do, which is to say we really only care about issuing orders if there is material that is over the guidelines, if there is material that is off-site. But now we're back to the old regime. We're back to depending on ministry application of policy. We're back to depending on the local district office, and we're back to depending on the local provincial officer or director applying that discretion, which is where I think we're trying to get away from under this regime. Two other points I want to make. I know we're running a little bit short on time. And that is, I guess, a bit of a potential good news for the civil litigators out there. A lot of my work is in civil litigation. A large amount of that is defense of civil action. So that's my bias when I read these things. And I see some side benefits. The Act specifically says that these changes aren't supposed to affect any cause of action. And I take that to mean the cause of action, the right to sue. But it may well have serious impacts on defenses that are available to you if you're defending under these claims. the registry is notice to the world of what you put out, of what's in the record of site condition. The registry contains at least information about that's contained within the record of site condition itself. It won't tell you all the details because the reports aren't part of what's on the registry, and the reports may not be available to you. However, the registry is, for the first time in my view, a realistic mechanism for an owner to communicate across time. For the first time, we have an ability to communicate down the chain of title to future owners. Not just the only real ability to communicate today is with your purchaser. You can give full disclosure to them, but there are instances when even with all the disclosure, even with a vendor giving a discount to property, 2 or 3 or 4 or 5 owners down the road, suddenly a new purchaser comes in, maybe redevelops, standards are now more stringent, and suddenly they say they were taken by surprise by what that first owner left behind, and civil liability may well follow as a result. For the first time, if an owner takes advantage of the registry, there's an ability to communicate across time to those future owners and to tell them at least what the owner is capable of telling them. And from a civil litigation point of view, cases like Tony's Broadloom tell you you don't need to disclose much. You don't need to tell that purchaser down the chain of title everything that you know. Frankly, if you tell them enough to say go and do your own phase 2, that's probably enough, because at that point everything on site is discoverable to that future owner. So I think that's a very significant side benefit to the record of site condition. Similarly, and my final point is, again, as practitioners, we shouldn't lose sight of the new Limitations Act. 2-year limitation period in general, 15-year absolute limitation even for undiscovered claims, but no limitation at all for undiscovered environmental claims under Section 17 of that Act. So again, liability in tort is potentially unlimited in time unless you find some way of starting that clock running. And again, if you take advantage of the record of site condition, take advantage of the registry, you've now given notice to the world. And I think you've started those clocks running, and I think there's a mechanism now to at least protect our clients against the potentially very onerous implications of Section 17. Because again, now what's on the registry is notice to the world, and what's the information underlying that, if available from nowhere else, if you can't get hold of the reports, if you can't get hold of them from anywhere else, well, if there's anything that matters, it's in the ground still. So if you know that there's something that has been registered on this site, the very least you should be doing, if you can't get any information, is doing a phase 2. So I think at that point, something which has been a bit of a sleeper, which is what's going to happen with Section 17. I think if you don't want to lose too much sleep over Section 17 of the Limitations Act, look seriously at the benefits of a record of site condition. The interesting thing is I think, even if that at some point there's a determination by the ministry that there is false or misleading information of some sort, you probably still have the protection on the civil litigation front, because you still give a notice of something. There's still the ability to do the phase 2. So you may end up registering, you may lose the protection from future orders, but you may still have the benefit from future claims as a viable defense to a plaintiff saying you really should have known about this before you got into the problem you're now complaining about. And I think that's all we have for time. So.
Thanks, Bryan. Marc, I could just throw one question back to Laura, and then we can talk about how you're going to manage other questions you've got. But I thought perhaps it might be good for Laura to respond to a couple of Bryan's points in particular, and anything else you might want to talk about, Laura, for a second or two. I was thinking in terms of the protection for old or former owners, one thing, and the other one potentially is Bryan's comments on the offsite. I'd be interested in hearing from you.
Sure. The prior owner's point, as I understand it, is the concern is the extension of the protection was not given to prior owners. The intention of that, the policy choice, however you want to, sort of capture it, is that the ministry wants to preserve its ability to order in prior owners in situations where, notwithstanding the fact that there's an RSC that's been done and there's been no false or misleading information in it, that something was missed, not through any fault of anyone, but something was missed. There was a hot spot, there's a tank that was missed or whatever. And so the idea is you want to be able to, again, open up that order ability so that you can reach back and look to prior owners who perhaps, not in the scenario that Bryan sort of mapped out for us, but perhaps didn't turn their mind to remediation. So, and perhaps there is a further smaller, exception where, there's some kind of declaration or something. But the policy choice was, look, in situations with notwithstanding the fact that there's an RSC, something's missed, the ministry still, you might not want to look to the current owner because they did an RSC. So let's look back in time and capture those people who may have been responsible for the discharge and be able to order them, because the choice is always taxpayer or, people who at some point benefited from the ownership of the property. On the offsite, I don't know if it addresses it, but you probably don't have time to tell me whether it addresses it, but we can talk later.
If I can just briefly just add one line to it, Laura. What you've said is narrower than what the legislation is. It would be nice if it simply said, this is only if something is missed, or if it's only for what is not disclosed. And maybe in the future, that's something that could be considered, because I think that would certainly be much more comfort to, to a prior owner to have that ability to do that, especially if they complied with the standard of the day.
Well, the thing is, the structure of the legislation, and it's a point that I want to make on the offsite point as well, is that what we're talking about in 168.7 is you lose a protection, and what happens is you just get fed back into the order regime. So yes, it's narrower than what 168.7 says, but now we have to look at the jurisdictional hurdles under 1718. And so actually I think it would, and there is a certain amount of discretion to it, and of course I would say it's not so bad, the discretion of the directors. You might have a different view of that. But yeah, you're kicked into that regime, and there is a discretion, and I don't think it is actually narrow. It's narrower certainly than 168.7, but I don't think it's actually narrower than how 17 and 18 are actually administered. So then on the offsite issue, so again, as I understand the concern, what happened, you sort of, Bryan, read the section and said, well, look, it's any contaminant, any bit of contaminant that goes off site. My first response to that is, yes, any contaminant that goes off site then triggers the loss of the protection, and then the jurisdictional hurdles of 17 and 18, which and 157 or 157.1, are then triggered, and that is actually a narrowing of scope. It's not any molecule. There has to be, harm or likely harm or adverse effect or likely adverse effect. So it's not any molecule. I think that probably, that doesn't meet the jurisdictional requirements of 17 and 18. And then in terms of what do you tell your clients, because you could lose this protection? The idea of an RSC is that it's a certification that a site is clean. And when we say clean, as Katherine said, how clean is clean? Well, clean is to ministry standards. The standard, you go behind those standards, the standards are meant to address no risk or acceptable risk of offsite or no offsite contamination. So you clean to the RSC standard or the standards that the ministry has set, and there shouldn't be a problem with offsite. So maybe that's the first thing you tell your client. And if you actually do have a concern about offsite, then you should be considering at least doing a risk assessment, in which case, again, I think that, yes, there's that opening, but I think as a practical matter, if you're cleaning up to the standards, as a practical matter, you shouldn't have a problem with offsite. Okay, you do have a problem with it, an unforeseeable problem. Well, the worst thing that happens is you get kicked into the 17 and 18 regime, and then the jurisdictional requirements apply, and then, yes, you rely on the discretion of the director, but there is an opportunity to say, I exercised my due diligence, I did everything I could, and then that debate happens. I don't think that's such a bad thing, because the bottom line is there's contamination. Something has to be done about it. Who's going to do it? The taxpayers or the property owner? I think those are the only 2 points. I had another response, but I know that we're running out of time, so.
Okay. Well, I'll hand back to Marc and Alexandra to see if there's other questions.
Thank you to our panel for discussing liability and all of its implications. We do have some questions from Toronto, and we also will be checking in with the operator in respect of the ILN centers that are looking at this broadcast for their questions. And I think they're supposed to press star 22 in order to put their questions forward, and we'll get notice as to where they are. In terms of questions that have already come up from the floor here, it fits in well, I think, with the discussion that we've just been having. There's been a question, a question that pulls together so many threads from today. This is voluntary right now. So when do I tell my clients to go the route of filing an RSC? And Bryan, I think in his comments, has said you're getting an increased protection in the potential liability. So there's an advantage there that you wouldn't experience otherwise. That you have to consider hard the downside. I wonder, Katherine, if you might comment on what you think that downside could be. And you know, we've talked a little bit about subsequent owners of the property. Are there any other people out there who might have seen something on the registry that might come pursuing the registrant?
Actually, I thought you were going to ask me what the further advantages are of filing a record of site condition, because I can think of a lot of transactional advantages and advantages from a baseline, drawing a baseline perspective, perhaps if you're selling property that I think are real advantages for our clients who are considering whether they should go the RSC route. I think one thing that we're all going to have to turn our minds to is whether this RSC process is going to significantly increase the cost of doing the work that our clients traditionally would do in terms of phase 1, phase 2's remediation, whether this is really going to be worth their while at the end of the day to achieve this kind of protection. So I think that's one thing that, apart from a liability perspective, that they should be taking into consideration. In terms of potential liability going forward, I think I touched on that a little bit previously. I think this really remains to be seen. Our parties, by actually going through this essentially public process of now putting information forward with respect to their properties, are they better off to do that by getting the protections that Bryan has mentioned in terms of disclosure to all the world, or are they putting themselves at risk for making certain representations concerning their properties? And I think that's just going to be something that we're going to have to evaluate as we go forward through this system. One other comment, though, I think is sometimes our clients are not going to have the luxury of deciding for themselves whether they're going to go the RSC process. I think we're increasingly going to see the drivers coming from financial institutions who may say, we want the record of site condition as a condition of the financing on this project, and that decision will essentially be taken out of their hands.
Thank you. If there are other panelists from earlier in the day who can come up and join us, I know Donna and Norm are here. We'd love to have you up on the stage so that you're handy to respond to questions that come up, and we will be checking in with the operator to confirm whether there are questions from our other areas. But the second question that's been put forward today, and it's a question that deals with again, the impact of the registration. The question is, does the RSC registry or any other aspect of the new amendments render moot the common law obligation of vendors to disclose latent defects? Now, that's a question that a number of you could have, related to the talks that you have. Bryan, if you want to comment on that.
Well, yeah, and I think that's exactly the issue that is being disclosed by the registry. I think, as a matter of prudence, the obligation should still be there contractually between the vendor and the purchaser. I think I always take the philosophy that it's a good idea to disclose. If it's a problem, find out now rather than later. I just as soon not find out 2-3 years later that there is a problem. But in theory, if you've disclosed it, if it's on the registry, it's certainly available to the purchaser to search and to find out. I guess at that point I would say we don't really have a latent defect anymore, because at that point it's it's now available, so it's not really latent. The latent defect is something else entirely. Once it's on the registry, I think you've given that disclosure.
Thank you. We're just going to check in and see if any of the other centers have any questions. I'm supposed to ask if the bridge operator has any questions from any other ILN locations.
There are no questions from the ILN locations.
Thank you. We do have another question here from Toronto, but Norm, if you wanted to comment now.
The one topic that has been touched on by a couple of speakers that sort of follows from what you just said, that I think is worth getting the panel to discuss, and that is what you see on the registry is not the whole story. And the problem that we've got is there's nothing in the current system that makes sure that the reports, which is the whole story, is in fact available forever and ever. There, in the legislation, it does put a requirement on the consultant, the qualified person, the firm that the individual works for, to maintain the reports for 7 years. I asked Jamie why 7 years, and he didn't know. I'll have to ask Larry Fox, or I'll check that later. To my mind, back to my days when I was practicing, you make copies and you keep them however you can forever and a day. That's your evidence, as Bryan was talking about. And then the other aspect is it our role as lawyers to read those reports carefully before we allow the client to sign the owner's statement and to put something on the registry? I always enjoyed reading those reports, Catherine. I know you do too.
I think on a related point there is going to be, I think, an additional imperative for us as council. There's going to be another area of due diligence here, that if we've got a situation where there's a record of site condition, there is going to be now norms for what you as council are going to have to review and inform your client about and ensure your client understands when reviewing those records of site condition themselves and what they contain. I think there's another dynamic that I think we're seeing a transition, and that is, typically our clients would want to keep environmental information about their properties fairly confidential. They didn't want the whole world to know about them. I think what we're seeing is a movement towards greater disclosure. Now there's going to be these formal disclosures through registries, and I think we're going to see that translate into a greater willingness by our clients to share this kind of information, whether it's by providing reports when they're requested, even if they're not required to be filed with the ministry.
Just on that, sorry, Don, just on that point, Catherine, I think that there is an opportunity for lawyers and even consultants and clients to be lulled into a sort of false sense of security. We're going to have a record of site condition for a property that is registered on the environmental site registry, filed on the environmental site registry, that says that the site is clean. And I'm not sure if it was, I think Bryan, you had mentioned, or maybe Catherine, you had mentioned, well, that may provide some certainly information and maybe some protection for the past, but not the future. And I just caution all of us to be thinking about what the record of site condition is actually telling us, and for what period of time. And I pose the question more generally to the group: do we need to look behind that in the throes of a transaction, for example, and how do we go about doing that?
Well, I just want to kind of continue on from that. What if my QP doesn't like your QP's opinion? And I'm not even talking about when somebody's QP is not really a QP. Let's just say we really have QPs with different views, and it's not like we've not seen it before. What are we going to do? And how are we going to tell our clients to go forward or not go forward, or whether the protection's there or lost, or if it's new information, or if it's misrepresentation? And how are we going to get the reports to be able to have the QP we retain evaluate the first QP's stuff? Because meanwhile, I'm not dealing with the owner who signed. I'm dealing with however many years later. And when the owner who signed sold, the reports didn't move along. So now I'm trying to find some dead owner, defunct company with no reports. That's 16 questions, sorry. Are we allowed to ask questions?
There are many, many questions and maybe not so many answers that are so definitive.
But if I can just add, I'm not going to in any way try to or propose to give an answer to what Donna just said, but I think as time goes by, as the date of registration gets further and further into the past, the relevance of the content becomes less important because obviously you've had more use. But I think the really important part of the registry and the real answer in the end as to what the new QP thinks is to go there and look. And that's really the key, is this is notice to people to say, here's what was found 5, 10 years ago, here's what we said about it then. You've got no excuse now for not doing your own phase 2. And that's the only way you'll know for sure what's there.
That's right. I think that's right. Yeah, I absolutely agree with you.
The last question that we have from the Toronto group, and certainly if people here have questions, I would invite you, even if you haven't dropped something in the box, to just let us know, and we'll repeat them so the ILN center's here as well. But the last question was more a question of where the municipality sits on this, and if there's anything in the legislation that requires a municipality to take particular notice of, it may be the questioner is asking about a cleanup order, the municipality not taking notice, going ahead and issuing a building permit. But it could be under a certificate of prohibition, a certificate of property use. It could be something that was noted in the record of site condition. Is there, do any of you see an obligation on the part of municipalities to address this prior to issuance of building permits? Do you think there's any guidance there?
I was at a conference just last week where municipalities were the primary people of the conference, and it was quite clear from that they're struggling to understand how it's all going to work. And I have to agree, we don't know all the answers. But I think you're right, they are on notice, and they've got an obligation to do certain things. And whether some municipalities will do as Toronto did and require a peer review because they haven't got the resources, I don't know. But clearly the least that they should do is they've got to get that reliance letter from the persons that signed the record of site condition, because otherwise they don't necessarily have that link. And so this is an area that I know the ministry is working with the municipalities, and that's one of the reasons why there's the year delay before that part of this regime comes into force and the building permit stuff kicks in, because these details haven't been worked out.
The one comment I'd have is that for municipalities that we act for, I'm not sure on the sort of run-of-the-mill development or smaller brownfields or smaller contaminated sites how they'll be handled. On the larger ones, what we're seeing is a move towards fairly comprehensive peer review, and but it raises questions as well, because the greater the more comprehensive nature of the peer review, does that raise additional liability for the municipalities? And there's a real push and pull between just accepting a qualified person's credentials on the other side of the table in a negotiation as a municipality, and not wanting to gauge your own peer reviewer to muddy it up a bit more. But so far I've seen a significant move towards from several municipalities the approach of really engaging more, just notwithstanding the fact that there may be some pitfalls in that.
Alex, one approach that a municipality can perhaps use where the issue of brownfield redevelopment and dealing with contaminated land is not set out in their official plan, as one example, is on an official plan amendment or a zoning bylaw amendment application, the municipality can resort back to two provisions in the Planning Act. I believe it's section 22 and 34 that requires an applicant to provide quote unquote other information that is relevant to the municipality's review of the application. Something to keep in mind.
Well, I think what you've seen today is that we're in the early days of this legislation, understanding what it's going to mean. You've received several practice tips throughout the day that highlight the issues that we're aware of now. But as you've heard from just this last comment, a lot of this is going to depend on what lenders are doing, what municipalities are doing, in order to establish what our clients are going to be required to do and what they're going to need. So it is interesting times, and I want to thank all of the panelists today. They've put in a great deal of time and effort so that they could come forward and try and explain this new legislation to you. I hope that you've got some tools to take forward. I know that each of them would be happy to speak with individuals who have further questions, and thank you for all of your time this morning.
I just have one announcement from the Law Society, and that is that this program was advertised at some point in time somewhere for a 9 a.m. start. This has been brought to the Law Society's attention. The Law Society apologizes, and each of us by email will receive a link to the webcast. So for those of you that missed the first few minutes of the program, you can check it out. For those of you that wish to see it again, you'll have that opportunity as well. Thanks.
Evaluation forms can be dropped on your way out. Thank you.